Hi, this is Judge Herb Dodell. For a while now, we've been talking about insurance claims based mainly on the most recent fires in California and other catastrophic events across the country. We've been dealing with insurance issues, terms and conditions, giving you some guidelines. So I want to go back now to general litigation, which would include litigation against an insurance company. So I want to talk a little bit about a couple of concepts. The first of which is dealing with impeachment of witnesses. So this is kind of back to the anatomy of a trial, but since it involves insurance as well, I think you can put it together without being too much of an overlap. Impeachment of a witness. What does that mean? If there's a witness against your position in the case, you want to discredit that witness. How do you discredit a witness? You show that they're lying. And if you can prove that, that's great. And I'm going to give you an example of how you can. If you can show that they have a motive, an interest, and a bias, those are the magic words from the evidence code, meaning that that person's testimony should not be believed because they have an interest in the outcome. In other words, if they have something on a contingency and they're the expert witness, you can say, well, aren't you dependent on getting paid according to the outcome of the case? Well, if it's true, your credibility, your expert's credibility is going to be adversely affected. If they have an interest in the case, or they have a bias, they don't like the other side, and it's been obvious, or whatever it may very well be, that's another area of what's called impeachment. Now, impeachment can be done very effectively, but two basic devices. The first is the use of a prior inconsistent statement that you can prove. That's one way of impeaching a witness. And here's an example. In a case involving an accountant, where the accountant claimed that the customer or client didn't tell them things, and that's why they didn't include them in their tax returns. They never knew. The witness testified, never knew, never was told anything, had no way of finding out. Well, it turns out that that very same accountant had contacted one of the state agencies and asked them to change the address from the address of the customer to their address, to them. So therefore, what does that mean? It means they knew. So the testimony that they didn't know is impeached by the documentary evidence that they were getting notices from the various state agencies, and therefore they did know. It is also important that you recognize the motivation of that witness. If they're a party, obviously they have a different motive than just a simple third-party witness who comes in. But this is one of the major elements, and it takes place during something called cross-examination. Cross-examination is generally done by asking leading questions of the other witness, of the witness. For example, isn't it true that on such and such a date you testified in a deposition that a certain thing had happened? They say yes or no. You've got the transcript to say that they did know. And the bottom line is you use that to impeach them. The same thing with a document that they may have signed or a statement they may have made. Just watch out for what's called the hearsay rule. We've discussed that. If you want to know about hearsay, two ways to do that. One, you can watch the show For the People, which is available at iHeart, where we talk about hearsay, or the book From the Trench to the Bench that I've written on the subject will tell you all you need to know about hearsay, when it's acceptable, when it's not, exceptions, exclusions, and the rest. That will be helpful to you in any insurance litigation that you may have down the road. So I recommend the book because it's an easy read. Or if you got any questions, contact me at askjudgeherb@gmail.com, and I'll be happy to give you some guidelines. I won't give you any legal advice, but I will be happy to give you some guidelines, all without cost to you.